going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. This is part two of the petty attorneys. They're back. If you remember from part one, they are arguing over a restaurant. The owners of the restaurant evicted the tenant who owned the owners of the building evicted the owners of the restaurant. So that happened in the last case. The attorneys went back and forth. It was kind of ugly and funny to watch all at the same time. This is part two. They're not getting along still. All the restaurant owners want their stuff. The building owners claim it's theirs. Yeah, it's just be ready for the pettiness. All right. Hopefully that intro made sense because I haven't had coffee yet. It doesn't make sense to me, but we'll watch it together. Before I hit that play button, you know what to do. Hit the like and subscribe to your Jump Kick Backflips. Let's go.
How about Flushing Investments LLC versus LL Restaurant Inc.
I'm Alex Benson on behalf of the plaintiff, Your Honor. I'm present.
Okay, Mr. Benson, and
Good morning, Your Honor. Richard Sabo on behalf of LL Restaurant.
okay, gosh, this is the matter we had at trial. There's a judgment. I guess, Mr. Sabo, this is your motion to retrieve personal property, it looks like.
Yeah, correct, Your Honor. We had the hearing, as you may recall, on the first. That was 28 days ago. Still to date, we do not have our personal property, nor have we been allowed in the property. We've made several attempts. We provided a list. There's been several reasons for not providing it. And again, now we're coming before the court to simply ask that we be allowed to retrieve our personal property.
Okay. Mr. Benson?
Yes, Your Honor. So factually, I filed a response and I would just draw your attention to a couple of things. The first issue is that per the court's order, the defendant has 21 days collectively with us to select a date for them to remove their property and get it out of there. That 21 days hasn't expired, as the order you signed was signed on April 14th. So it's premature. So that's a separate issue I want to address after. But the issue I want to address, and I want to draw the court's attention to, I believe it's Exhibit D of my response brief, Your Honor. Rather, I apologize, Exhibit C. So in Exhibit C, we say to them, you've requested certain items. They're not yours, they're appurtenances. And if there are items that you want, just give us the receipts and a real list. The list that we got can be found in my response. He literally just asks for anything. He says, we want to come get our personal property. And I'm like, well, give me receipts. Give me verification of what's yours. He's asking for coolers. He's asking for booths. He's asking for items that are clearly appurtenances. He's asking for chairs, tables, all these things that are appurtenances. So I'm like, look, give me a list of the items that are yours and verification they're yours, and we'll arrange it. I go through, if you look in my email, the 6 different items they've asked for. Because any tables or chairs for which your client does not have proof of ownership. I'm like, well, just give us the receipts. If they're yours, they're yours. Kitchen equipment that is affixed to the property, which are appurtenances. You don't get that. That's an appurtenance. It's attached to the property. He wants cushions or new booths that were installed. I say, well, you don't get that if it's installed to the building. That's no different than paint or wallpaper. The ice machine and dishwasher. These are affixed to the property. They're not their property. I said, and then he says he wants inside and outside coolers. I said, we need to understand what you're talking about. We believe the coolers are either owned by my client, meaning the owner of Flushing. If you believe the coolers are yours, just give us verification. Give me receipts. Then a proof of sale system. If they are not connected to the property such that they are an appurtenance, your client has verification of ownership, your client may remove. I then say, my client has availability to allow your client in the property this week. That was last week. Please provide the above documentation so we can ensure an orderly transfer of the property that your client's legally entitled to. So I guess this leads me back to, why am I here, Judge? Why am I billing my client for this motion?
And
I
Your
think
Honor,
this clearly is violative of MCR 2.1109 E67.
Your Honor,
All right, let's break down some of these things he's asking for. As someone that worked in the restaurant industry for a long time, I know exactly what he's talking about. So the booths, yeah, I don't think you're gonna get those back. The cushions, yeah, I think the attorney's right. You install those to the building. I don't think you can ask for those back. The loose tables and chairs, if you purchase them, I mean, I don't see why he wouldn't get those back. Kitchen equipment, yeah, good luck with that. If it's not just something you can pick up and take with you, then I don't know if you're going to get that back. Some of that kitchen equipment is really expensive, though. So if he did buy them, if the owner bought them or the restaurant owner did, then yeah, absolutely show proof and get that back. That stuff can be crazy. The ice machines, that can go both ways. Most ice machines are movable; they're on wheels because they need to be cleaned very regularly, which a lot of restaurants forget to do, and they always get marked up by that when the health department comes around. But the ice machines, depending on if he actually bought them, he'll get those back. And then the cooler is vague. You mean a spare refrigerator? And why are you keeping one outside? I don't think you're allowed to do that. Just saying. I don't know why you have a cooler outside, but cooler is a vague term. It can mean anything. All right, let's keep going.
let me take a step back here. I
Sure.
emailed over to the court a stock purchase agreement, and defendant, they're very well aware of it because we purchased it from them. We purchased the restaurant in 2023 for $500,000. That restaurant came with furniture, fixtures, and equipment similar to what I listed. He knows we have no receipts. We can't have receipts because we bought the stock in the restaurant which owned these items. And again, Your Honor, I did email that for your review. I also emailed over to you the tax return for 2023, where we listed $110,000 of personal, I'm sorry, $105,510 of personal property. For defense counsel to say tables and chairs are appurtenances is absolutely ridiculous. There can be an argument, and we can have that over other items such as a dishwasher. But tables and chairs, coolers that are not affixed. These aren't the refrigeration system, Your Honor. We agree that's theirs, and that's in the lease. And if you look, there even is a section, furniture, fixtures, and equipment, that says, quote, upon expiration of the lease term of this lease, tenant shall remove all of his trade fixtures and equipment from the demised premise. Period. Lighting fixtures, walk-in refrigeration systems, and HVAC systems and appurtenances shall not be included in tenants' trade fixtures and shall be left in the demised premise and shall become the sole property of landlord upon expiration or earlier termination of this lease. So we acknowledge, Your Honor, we're not taking light fixtures. We're not taking walk-in refrigeration system. There are certain things where we are not entitled to, but we are entitled to the items that are owned by LL Restaurant, including limited to the list I had. At a very minimum, Your Honor, I would like the opportunity for my client to enter the premises with defendant, take out at a minimum tables and chairs, which of course are not appurtenances. We can then make a very specific list of every item. And then we cannot agree, Your Honor, come back before Your Honor. In addition, Your Honor, there are other items which are not owned by us, like the POS system. That is not owned by us. And again, my client can testify to that fact. There's other items as well. There's the DJ and band equipment owned by Brandon Wooten. Again, not ours. We're not able, Your Honor, to get in to get any of these items or even look at them. So in the event Your Honor is not willing to grant the relief in my motion, I at a minimum would like the very common items that we know are not appurtenances for him to be able to get, and then make a specific list of other items for us to then come back before Your Honor.
Your Honor, I return to my Exhibit C, where I said to him, give me a list of the specific items you think you're entitled to, and we'll schedule, wait, easy, don't interrupt me, and we'll schedule a date for them to do it. That was not responded to. No response to that email last week, Your Honor. This motion is really, really, frankly, inappropriate. It's untimely, and it was just a waste of my client to have to pay me to appear for this, Your Honor.
So
They're just not responding.
And Your Honor, that's not correct. If you look, there's multiple days where he denied us coming into the property. He also asked for a signature on a document that we already signed. That was one of his prereqs. Nothing with this transaction, Your Honor. This is just an absolute farce. My client is trying to reestablish his business at another location and just trying to get his personal property. Very basic, Your Honor.
Well, I think honestly, for both of you, I am surprised it's gone this far with it. I think on Mr. Benson, they should have an opportunity to come on the premises and everybody present and move out the things that we know are not plaintiffs. You know, and that's kind of the easy part to start.
All I've done
with.
is ask for that list, Your Honor.
Okay, yeah, I understand, Mr. Benson, and I was just gonna say, Mr. Sabo, well, I don't have the list in front of me. Apparently, you emailed it over at some point.
No. The list is in my motion, and I included in there, Your Honor, tables and chairs. So
Oh, I'm sorry. I thought you said you emailed something else over to me.
He emailed over a tax filing, and he put in there what they claimed was the value of their property, as if that was some sort of evidence, which I fail to see.
Your Honor, I did include tables, chairs. There's kitchen equipment like bowls, plates, silverware. I mean, these things are so basic.
It doesn't say that in your list.
That's kitchen equipment. Your Honor, this is how big is the facility?
Hey, guys, this is like a.
It's a $20,000. It's a 20,000 square foot facility. I can't name every.
Let's just make it real easy. Let's pick a time where attorneys and everybody can go on the property and either tag them to get them out within a reasonable time period, or move them out that day. I don't care either way.
The only issue is, what if we don't agree on the
Well,
property?
then you're going to be back here, Mr. Benson.
Oh, I just want to
let 'em
clear
on.
that if we don't agree, it doesn't move. That's all.
Your Honor,
Okay.
can we agree on just minor items like tables and chairs?
The problem is I'm worried that both sides are talking about different items is all.
Oh,
I
I'm
don't
saying
know.
tables and chairs.
Well, your list says booths and cushions.
Oh, no, my list is much bigger than that. I'm simply saying, can we agree tables and chairs?
You now see the problem, Judge.
Let's
What
kind of get
problem?
through table. Are there tables and chairs that are, I guess, not attached to anything? They're just
We're not talking booths, correct?
freestanding?
These aren't booths. These are
Yeah.
freestanding
Yes.
tables and chairs.
That's all they can do. Yeah, that we agree that they can have the freestanding, unattached tables and chairs. There's very little else we agree to, Your Honor. In other words, if there's a point of, if there's music equipment that belongs to someone, we don't have a problem with them taking it if it's not ours. If there's a point of sale system that isn't ours, we don't have a problem with them taking it as long as they don't damage our facility in so doing it.
So
let's.
is there a
so-
date, Your Honor, that we could agree right now?
Let's-
Because again, it's been very contentious on this. So I would
Yeah, let's
love to
just
get a
get a-
date right now.
Let's just get a date, have everybody meet over there and.
Yeah, but I just wanted agreed and understood on the record that if there's not an agreement on something, they
You
can't
come
take it.
back.
Agreed.
Yeah, I want it
You-
understood
yeah.
that we'll have to come, they cannot remove it.
Mr. Benson, that's what he just agreed to that.
Okay,
just
I
agreed
didn't
with
hear that.
Yes.
You guys, I would expect the two attorneys would be a little bit more mature and be able to say, you know what, if there's something we're not going to agree to, we'll be back. This
Agreed.
is turning into a divorce case, which is ridiculous. I'm
Agreed.
not going to do that. Okay. So what we're going to do is set a date. The attorneys are going to be there. We'll get the items out that everybody agrees to, and then we'll go from there. Okay.
Your Honor,
So what
can-
time?
Judge nailed it. This is absolutely turning into a divorce case. And yeah, I will link part 1 in the description. You guys need to go back and watch part 1 if you haven't seen it. It is equally as good. Well, it's actually a little bit better because they're actually fighting over the divorce at that point because one of the parties didn't want to be divorced and the other party's like, yeah, no, this relationship isn't working. So that one was kind of funny. The pettiness was through the roof in that one. This one, they're just like tic-tacking each other. Yeah, you know what? Let's just have this play out. But yeah, go check out part 1.
Yeah, a beloved
Do
date.
Friday.
My client is available.
I cannot do next week when we got this surgery. This
So
is
nice. I'm having surgery also.
Oh, yeah.
Can we do Wednesday? Can we do tomorrow?
No, I have court all day tomorrow, Your Honor. I can do Friday. And then I can't do next week because I'm having open heart surgery next week, Your Honor. So I can do Friday.
What about Friday? Does that work?
You're gone Thursday, Friday. That's the only 2 days you can't.
I don't know what to tell you then. I'm in court all day tomorrow. I'm in court Thursday morning. I suppose I could do it Thursday afternoon and move what I have.
No, Thursday. What? Okay, then. Hey, Mr. Benson, when then would you be available after next week?
I'm having open heart surgery. It's probably 6 weeks.
Well,
Everybody
is
just go.
there a
there time
stand-in
that-
though? I mean, is there someone a representative that could be there?
I
I mean,
haven't
you
even
can't wait.
considered that. I haven't even, I
Well,
don't
let's
know is
get-
the answer.
Guys, if I'm just gonna pick a date, we're gonna pick one. And honestly, it's kind of ridiculous. You guys can't even agree to a time.
Agreed.
I've given you two dates this week.
He
What-
leaves Thursday. He can't do it is Thursday through Monday. Any other day he can do it.
Well, there's several owners. Doesn't he have someone else who could be there?
We do it. He's the main operator.
Okay,
Well,
as
I
a,
think,
as a,
you know what, why can't he be there? Mr. Zabel. Well, either
Okay,
Thursday, I'm sorry.
Oh yeah, he just said he can have he'll have a representative there with either a recording or a FaceTime so he can at least see what's going on. So we could accommodate Mr. Benson. And
so why don't we do Friday?
Friday. Okay, how about
Okay.
Friday? All right,
All
Friday was 10 a.m., 9 a.m.
Well, I have court first thing in the morning. I was thinking Friday afternoon.
Can we do it earlier? The only thing that I have is late afternoon meetings. 11 a.m.
Sure.
Okay, all right, 11 a.m. on Friday.
Okay, so May 2nd at 11 o'clock, everybody, whoever's gonna be with authority there is gonna show up
Yes.
May 2nd, 11, okay?
Yep. Perfect.
All right,
Awesome.
all right, guys.
And then Your Honor,
Oh, it's not over yet. They're gonna. I mean, I agree with the judge. It takes them that long to find a date, and I like how this attorney Sabo acts like he's doing them a favor. We'll give him this. We'll give him this one. We'll pick this date. Hey, your client's the one who wants this stuff. He's having open heart surgery next week. And he's like, what about the week after? Like, Anyways, I'm gonna let the rest of this play out. They're still gonna argue over schedule for about 2 or 3 more minutes. Yeah. I'm done with these two. Hopefully this is the last time we have to cover that, or I have to cover them. But they do set another date in case things don't go well. And I'm going to tell you, I don't think things are going to go well. I really wish I knew where this restaurant was. I would drive up there on Friday just to watch it for myself because it's going to be drama and it might actually be entertaining. All right, you guys are awesome. Please hit that like button. I would appreciate it. Until next time, bye.
do we have a return date? Can we set a control date?
I can just give, if you want one right now, we can do it.
I
or
think
if-
it's going to be good because we're going to need it, Your Honor. Unfortunately.
Okay, so I guess Mr. Benson, I understand you've got some health matters coming up. What?
Your Honor, I'm having surgery at the University of Michigan the week of May 5th. My understanding from my cardiothoracic surgeon is I will be there anywhere from 5 to 7 days.
Okay.
I then don't believe that I'll be mobile for 30 days from what I'm told. I'll be home,
Yeah.
but not able to get in a car or anything because I mean, not to go through it in detail, but they go through my
that's
sternum.
okay. Yeah. I
Yeah.
don't need details. Good. I understand it's a longer surgery. Mr. Sabo, what is there? Or Mr. Benson, do you have somebody that can fill in for you?
No, but I could do it. I could do it from Zoom probably, the end of May from my house. need be.
Your Sable,
know.
why don't you help me out? I don't know. I'm hopeful we're gonna get something
Like,
done in
let's say the
practice,
week
but-
of May 19th, I should be able to be available by Zoom, I would think.
Okay, Your Honor, we'll make that accommodation. How about the May 20th, Your Honor? That's a Tuesday.
Tuesday, okay.
All right, that's
May
it.
20th at,
We can,
yeah,
we can agree. And Your Honor, hopefully we can get everything out. That's our hope.
May 20th at 9:30. And I will say, for everybody's sake, if there are things that aren't agreeable, then everything stays there, though, for
Yep,
everybody's
agreed.
sake.
Yep,
It
yep.
stays in contact, it stays right there. We'll deal with it.
Awesome.
Okay.
All right.
So if
Thank you,
somebody
Your Honor.
moves if something gets moved, it's going to be an issue. Okay.
Yeah. Other than
All right.
the point of sale system and the table and chairs. We agree
Yeah.
with that. Okay, awesome. All right. Thank you, Your Honor.
All right, guys. We'll see you back
Thank
May
you, Your Honor.
20th. All right.
Thank you.
Good luck.
Take care.
Bye.